Hi, everyone. Good evening. My name is Din Liu, and I am a specialist in estate planning and a founding partner of Goldfarb and Liu. And we are in a boutique estate planning and elder law practice based in the LA area, specifically in Tarzana. And my law partner, who you see there to my right, is we welcome you tonight. Tonight's presentation of estate planning during the COVID-19 pandemic. And we invited the medical community and the first responders who are working on the front lines. Thank you so much for being there for us. And this is our way of being there for you. And I speak on behalf of the Asian Pacific American Bar Association of Los Angeles County, as well as a member of Goldfarb and Liu. As attorneys, we want to support you and be of service to you. And so thank you, APABA, for sponsoring this event. Thank you for my committee members as well. And I want to also thank my friend Therese for helping prepare the flyer, and thanking my staff for supporting us. A lot of them are hands on deck right now. So thank you very much. This presentation is being recorded, and the link to this recording will be available on our website. So if you miss any part of it, please feel free to watch it again. Please feel free to share this with friends who are unable to make it to this live event. We wanted to do it in the evening. Once you put your kids away, after a hard day, you can talk about death and dying, of course. So as a California attorney, and as California attorneys, Rebecca and I, this is a California-based presentation. If you are outside of California, then please be mindful that the laws and all of our references apply to California. We are also, just so you know, providing legal information and not advice. Nothing in this presentation should be interpreted or construed as legal advice. We don't have the opportunity to sit with you, hear your specific situation, and then apply the laws to your specific facts. So this presentation is meant to cover the basics and give you an overall on estate planning. And so during the presentation, I'm going to serve as the moderator. My law partner, Rebecca, will be providing the substantive portion of the presentation, but we encourage you to send me your questions, and we will try to answer them in a non-specific way so that it could apply to as many people. Your questions will be anonymous, and I will not use names. So please do send them to me using the chat function. Only I can see them during the question and answer period. We will try to answer all of your questions as best as we could. That's when I will come back. And so I'd like to introduce you to Rebecca Goldfarb, my fabulous law partner, who will do the presentation, and I will see you shortly. Thank you.
Hi, everyone. Thank you so much for being here tonight and for taking all the steps that you're taking personally to help so many people. We are grateful for your commitment during this really scary time. So normally I do these presentations live. I get to see everybody in person. So this is the first one we've done while being recorded, where I just have to sit still on this couch. So I'm going to go kind of fast. We want to have time for questions. And if we don't get to all of your questions, then please contact us afterwards so that we can answer you by email or phone at a later time. So tonight we're going to talk about Estate Planning 101. We exclusively practice estate planning and elder law. So I'm going to throw in a little bit of elder law for those of you who have elderly family members or patients. We're going to provide some very basic estate planning documents. This is not a comprehensive estate plan. It will not protect you from all of the things that I'm going to talk about in the presentation, but it is it's a great beginning to getting your estate planning done. So we encourage you to spread the word. Part of our commitment at Goldfarb & Lew is that we teach as many people about the importance of these documents as possible. Most people who hear the words estate planning don't really think it applies to them because they don't have some huge estate or they're not really old. But as you will learn tonight, estate planning applies to everyone starting at 18 years old. And then we want to serve as a resource for you. So whether you have estate planning questions, elder law questions, or other questions, we're a resource hub for all of our clients and have a great team of referrals to help our community. So let's start first by talking about estate planning. Normally I get to say, how many people have one? And I see a raise of hands, but I'm not doing that tonight. So there are 4 main documents in an estate plan. The first one that all of you are familiar with is the Advanced Healthcare Directive. So this names someone who can make medical decisions for you, and it also states what your specific wishes are for care. And everyone over 18 needs that. You are not able to legally make decisions for someone once they turn 18. But I know that with the as many physicians that I've talked to and nurses, they violate HIPAA all the time. But technically speaking, you shouldn't be able to make decisions for someone over 18 once they've lost capacity. And the other one is the durable power of attorney for finance. So the healthcare directive is over everything about your body, and the power of attorney is everything else. So it's bills and dealing with taxes and insurance and one-day Social Security and all of those good things. Those 2 documents together, like I said, are for everyone once you turn 18. That's the baby estate plan that we talk about. If you do not have those and you lose mental capacity, whether it's due to an illness or an accident, then you're headed to conservatorship. We're going to talk about conservatorship a little bit later, but it suffices to say that it's a pretty horrendous court process that is very invasive and for most people avoidable if you have the advanced directive and power of attorney. And then if you are older than 18, maybe you have some assets, you have some kids, then we start talking about a trust and a will. So a trust and a will do the same thing in the big picture. They say who gets your stuff when you die, but all wills, or almost all wills, I should say, go through probate. And probate is another court process that we're going to talk about that's pretty expensive and very time consuming, and a public process as well. So in California, we're very trust-based once you have assets or kids, because we want to control from the grave. We want to avoid probate. So we'll talk more about these, but these are the main documents that we're creating in an estate plan. Tonight, in terms of the documents that we're providing, it's just the statutory Advanced Healthcare Directive, the statutory power of attorney, and a statutory will. We're not dealing with any trusts. Obviously, we need to have extensive conversations with clients to create these attorney drafted documents instead of the statutory ones. So I have to include some levity. I don't get to see anyone smiling or laughing, of course, but this, although estate planning is a super serious topic, we also have to have some times that we have smiles on our faces and laugh. So I say how to burden the people that you love is by not having a plan. That's the California default plan. So if you don't have an advanced directive, you don't have a power of attorney, you're headed to conservatorship if you lose mental capacity. And if you don't have a trust and you have some assets, you're headed to probate. And we want to avoid that. And the best gift that you can give someone is a regularly updated plans. These plans are not meant to create one time and then never deal with them again. It's really important. Life changes, the people you have as fiduciaries change, maybe the beneficiaries change. Certainly the laws change at times, so it's really important to keep this updated. So for those of you who have a plan, but you haven't looked at it in 5 or 10 years, it's definitely time to revisit that. So Din and I started our firm about 10 years ago, and we realized that our definition might be different than the standard that's out there. So here's our definition. I think it's higher than most estate planning attorneys I've talked to. A successful estate plan for us, first it has to honor your wishes. And in order to do that, we have to really dive deep into some uncomfortable subject matter. Some of what we do is therapy in these rooms. This is our lounge, by the way, that we meet with all of our clients. And we want to make sure that we understand your wishes. We also have to draft the documents really well so that it's clear. Sometimes mediate conversations between clients and their family members to make sure family will honor those wishes. We want to avoid court. So that means that in addition to the documents being comprehensive and complete, they have to be detailed and clear. And we have to fund your trust. So again, we're not talking about trusts, I know, tonight in terms of what we're providing for free, but we are, it is a big part of our practice. So we want to be sure that we retitle your assets into the name of the trust. It's not as significant what the trust says as in terms of, you know, this particular house is in the trust or whatever, that we were looking at the deed, we're looking at the owner of the assets on title or record. So that's funding the trust. And then probably the most important thing is to maintain family harmony. And that means that sometimes we have to think outside of the box. So these are really, really important concepts for us with our clients. We have a lot of client stories. I'm going to go through them very quickly. About 95% of the plans we see from other attorneys have a fatal flaw the client doesn't know about. So we tend to see one of these or more often when we're reviewing plans. So outdated documents are those that are not, those that are outdated, not just in terms of being old, but the players have changed in some capacity. So we had an example where a client came to us and his brother had passed away. His mother was over 100, and the bank refused to accept the death certificate of the brother, so they wouldn't honor the power of attorney at all. And we had to go up the chain of command and eventually threaten court. It was absolutely ridiculous. We see missing documents all the time where there might not be an advance directive, or the will might not be signed, or there's no power of attorney. Unfortunately, we see some poorly drafted documents a lot. And so where that counsel in combination with poorly drafted just wasn't done well. So for example, we had a couple and they were only named as each other's agents for power of attorney and for healthcare. The wife died unexpectedly, suddenly, and the husband had dementia, and we weren't able to fix that. And so we had to go through conservatorship because now his first in line was no longer around. So if they had had a backup person, we could have avoided the expense of conservatorship. So trusts not being funded, I kind of already talked about that. Selecting the wrong people happens all the time. So a lot of people will say, hey, and this kind of goes along with acting, my example with acting without good counsel. It's really important that you pick the right people. If you have more than one kid, we really recommend not picking them as co-trustees. So they end up in court sometimes. One client in particular I'm thinking of, this brother and sister were best friends and they will never speak again after the court case is over. So again, if you have any questions along the way, please use the chat so that Din can collect these questions. So all of you are familiar with the Advance Directive. We go into a lot of detail. Din and I have both been caregivers in our families, and we know how important this document is. If you're not able to speak for yourself, it's critical that someone knows your detailed wishes and can speak and make decisions on your behalf. So first, I'm going to whip through this really fast, but first we talk about who the agents are. You need to pick the right people. Not everybody is suited for the job of being an advocate and working with doctors and nurses and the medical teams. The effective date is important. We like to make them immediately effective almost all of the time. Otherwise, we have to have our clients go to doctors to deem them incapacitated in order for their agents to help. And doctors, from my experience, my mom's a doctor, they like to stay in their doctor realm and don't really like to cross over into our legal realm. So this can cause big delays in people being able to make decisions for you. We talk about the HIPAA waiver with everybody. It seems like so many people have allergies now, so we want to get that noted in their advance directives. Geriatric care managers are a huge resource to people when family members need help or when people don't have family to help. We've included an advanced driving directive in our advanced directive because on the elder law side, taking the keys away from someone is the first hardest thing we do. We talk about CPR and the pulse and obviously what that means with regard to a DNR. I don't think I have to go into a lot of detail with this group. Quality of life might be one of the most important things we address in detail, both mental quality of life and physical quality of life. Those definitions are different for every single person. And we want to make sure that once you've crossed that line of what quality of life would be for you, that your agent is making decisions in alignment with those values. We talk about organ donation and memorial. The My Wishes is something Din and I made up. So in the worst case scenario where you have some sort of, maybe Alzheimer's or a different type of dementia, if you're not able to communicate anything, it's better to be surrounded by all the things that give you comfort versus all the things that drive you crazy. And then we go into other details as well. The power of attorney is a faster document for us, but equally as important. The agents that you choose should, be people who are used to dealing with this day-to-day paperwork kind of stuff. The effective date we also make immediate, and there are types of powers that we talk about in terms of you have to be very specific if you want these powers given to your agent. So I don't know if anybody recognizes this picture, but what happens if you become incapacitated? This is TERRI SCHIAVO. She was in, she was in the 90s, early 90s. She was in her mid-20s. She fell down a flight of stairs, went into a coma. This is how she lived for about 10 years, and because you're in the medical community, I'm sure you can read this. The slide, the image on the left is an image of her brain, of a normal brain. The one on the right is her brain, and the black part is the dead part of her brain. So she was never going to come back to life. Her family duked this out for 10 years in court. And if she had had an advance directive, I'm sure she would have said she would not have wanted to live like that. So the saddest part to me about this story is that from what I can read, she was surrounded by law enforcement when they finally pulled her life support and not by her family when she died. So again, this advance directive and power of attorney is for everyone once you turn 18. Conservatorship. So conservatorship is if you are over 18 and you don't have the advance directive, you don't have the power of attorney, you've lost mental capacity, you're headed to conservatorship. Obviously, people know who that is. She has a conservatorship. It's where the judge is deciding who takes care of you and your health decisions and your finances. They can also take your voting rights, driving rights away. It's extraordinarily expensive. And it's permanent court intervention. You have to do an annual accounting of all the money that is spent on you. It doesn't matter if you're husband and wife. So my next slide is dear friends of ours, and he had an accident at work. This was about 20 years ago, and he was in a coma. He came out of it, and basically has the capacity of a 6-year-old. So Stacy has been taking care of him all this time. They had to go through conservatorship, and although now she only has to do her accounting every other year, she still has to account for every penny of the money that is spent on Vinny. And that could have been avoided if they had had the advance directive and power of attorney. So what happens after you pass away? There are 2 routes. One is probate and one is trust administration. I'm going to talk about probate first. So if you have no will, or even if you have a will, oops, this slide has to be updated. The law changed this year in terms of the amount. And you have over $166,250, so not that 150, that does not have beneficiary designations or transfer on death or pay on death, then you're headed to probate. So again, all wills go through probate if you have over that $166,250 where you have no beneficiaries or transfer or pay on death. So this is a public process. They have to determine if the will is valid. If the will is not valid, it goes through the law of intestacy. So it might not be the people you want receiving your estate. They have to determine who the executor or administrator will be, and you have to qualify for a bond. So if you don't have good credit, you don't have the right income, it's possible, depending upon the size of the estate, that that person you want to handle it might not be able to. It is super expensive. And completely 100% avoidable if you do a complete estate plan. Your assets are frozen for a period of time, which means that if it's a couple and the assets are in one person's name and that person passes away, there's going to be a period of time that those assets are frozen. We have to notify all creditors. Din is the one who does all of the court work at our firm. Now that the courts are closed, it's obviously taking longer than a year. One of our clients works for the Superior Court, and we were talking about it the other day, and she said there's going to be thousands of cases when the courts open, and they have no idea how they're going to address that. So I can't emphasize enough how important it is to create your comprehensive plan with a trust so that you avoid probate altogether. So these are the costs. As I mentioned, probate is triggered at that $166,250. You look at the fair market value of your estate. So if you have a house, you do not get to subtract the mortgage to come up with what your estate is how the probate fees are calculated. So let's just assume, you know, you have a $700,000 estate, including all of your assets. Then the probate fees will be around $34,000. Could be higher than that, depending upon the circumstance. Half of those fees go to your administrator, and half of those fees go to the lawyers. And I joke with people all the time, like, don't help me send my kid to college. Do your trust so that you're not wasting money on lawyers. So you can see that if you have a properly funded and drafted trust, you're going to avoid court. You're going to avoid those probate fees entirely. So trust administration, there's the easy, as my 5-year-old daughter would say, the easy peasy lemon squeezy way. You know, you've named the right trustees. We figure out your assets and debts and deal with the taxes. We follow the distribution pattern, and then you have family harmony. Sometimes the other way is you have a nightmare situation because you picked the wrong trustees. We might end up in court. We might end up in mediation. Maybe you did not fund all of your assets into the trust, so you didn't retitle them, which means then we have to petition the court with a Hegseth petition to pull it in, and that is expensive for us to go to court. So Then we deal with the debts, the taxes, and distribution, and potentially there's a family feud. And it's so sad to know that if these plans are done right, if they're communicated right, if we do the outside the box stuff that we recommend to our clients all the time, that we can prevent these family feuds and really continue with as much harmony as possible. I think that's probably easy for me to say because I'm an only child, so who am I going to fight with? But for those people with siblings, you know, we can make it better for sure. So I'm just going to quickly talk a little bit about elder law. For us, it begins when they start needing extra help. So it's not based on how old you are. It's not based on, you know, most of the time it's people in their 80s and 90s, but you could get a diagnosis early of, you know, early onset dementia, or you could have some other illness that strikes earlier. In that case, then we're dealing with elder law. So it's about 80% therapy, 20% law on my end of things. I'm the harmonizer person in the law firm. Din is the one who's excellent in court, so she would probably say it's higher on the law side than the therapy side. But we do a lot of hand-holding and therapy types of things in elder law. So from the statistics that I have heard over the years, about 50% of us over 80 will get dementia and may be susceptible to elder abuse. We're dealing with that every single day in our practice. Most of the time it's financial elder abuse, but there's lots of different types of elder abuse. So for those of you who are in the sandwich generation, you might have older parents you're taking care of and your kids. I highly recommend referring to elder law attorneys. We do things differently than traditional estate planning attorneys. And certainly if you have patients who are older, I cannot emphasize enough, if anyone is starting to get dementia, that's the time to go get all of this done. Once you lose capacity, we cannot create these documents for you anymore. And so it's really important to get them done or updated before there are capacity issues. So you've probably all seen a POLST. This is the Physician's Orders for Life-Sustaining Treatment. It has replaced our DNR. I went through the POLST training to be a POLST trainer, so I fill these out with clients. I do not sign them, of course. They have to be signed by the physician, but this is a big part of elder laws, making sure people's wishes get honored. So again, if you have any questions, please use the chat to send them to Din. I'm going to talk for a little bit longer, and then we're going to open up for questions. So we're going to talk about the statutory documents right now that we are providing on our website for free. We are only going to be talking about the advance directive, the power of attorney, and a will. So there's no such thing as a statutory trust, but at least these things will get you going a little bit if you don't have anything in place. So the statutory advance directive is a fill-in-the-blank form on our website. We're going to have the blank version, obviously, for you to use, as well as a sample to help you fill it in. And with the durable power of attorney, it is a quick form. It's 2 pages. It is important that you fill it out completely and that you get it notarized. So again, this one has to be notarized. The advance healthcare directive is just witnessed by 2 people. And then we have 2 different types of wills. So we have the statutory will, which is going to be on our website. It's a fill in the blank and it has to be witnessed. Then we have a holographic will, which is honored in California. It is not honored in every state. Like Din mentioned at the beginning, this is a very California specific webinar. So the holographic will has to be in your handwriting. So I'm going to say that again. The holographic will has to be in your handwriting. And it does not need to be witnessed. So we always recommend to people to name who you want to be the executor, and then name who's going to get what. Make sure that you're telling someone where the original is, because if it's a probate, we're going to need that original. So again, there are two different types. The one on the left is the statutory one. You'll need a couple of witnesses for that. If you want to handwrite it, you can do that, and it will. You don't need witnesses for that. So remember, do not assume that family, friends, and patients have an updated comprehensive estate plan. Please talk about it. I know with everything that's going on right now with this virus, more and more people are talking about it. We're hearing, people calling us every week who are really motivated to get this done because they're afraid of this. So I know that I remember years ago when one of my parents' first friends who died, and he was a lawyer, and they assumed that of course he had his estate plan done. He was a lawyer, for God's sakes, and he didn't have anything done. So really don't make assumptions on this. And I can't emphasize enough how important it is to have a really, really well-drafted comprehensive plan. So I know that I have gone through this really fast. I didn't want to go over the time to respect everybody's time tonight, but if we're going to get to questions in a minute, if you have any questions that you want to ask outside of the chat room, feel free to call us or email us. Visit our website. We have a lot of good information on there. And then that red tiny URL at the bottom, which is tinyurl.com/COVID-19 stat docs, is where you're going to find the statutory documents that we talked about. So the advance directive, the power of attorney, and the will. And then it's going to have samples for you to print out as well, so that it will help you when you're filling in the details. But remember, if you have kids or you have some assets, a trust is really, really important. It's the only way that you can sprinkle those assets over time to your kids. Otherwise, they get everything outright at 18, and that could be its own kind of disaster, right? I don't know any 18-year-olds who can handle, $5,000, let alone any more than that. So, and then if you want more information, send us an email. We're going to send out a checklist of things for you to think about, and I think that's it for me. And Din and I might go back and forth with these questions, and we'll take turns answering them. Again, we have not ever done this, so bear with us as you're sort of our guinea pigs. But it was really, really great to be here and talk to you and have the opportunity to teach you. And thank you for what you do for everybody. Okay, I'm not supposed to cry. All right. You're turned in.
Hi, thanks so much, Rebecca. That was a very good presentation. This is a very, very difficult time for everyone. So some days are better than others, I know for me. So yeah, thank you so much for what you do. We received several questions, and they're very good questions, so I'd like to get to them in turn. So just the first question then is, and I've kind of edited and modified this for clarity. So if you currently have an advance directive that is not immediate, in other words, it is effective upon your incapacity, and you get sick with COVID and become intubated, or let's say you have dementia, can your advance healthcare directive be edited to avoid two doctors having to declare you incapacitated for it to trigger? So there's a few issues there. Do you want to address? You want to take a first stab at it?
I'll take a first stab. So what I said earlier, and I know this is all new to everybody, so repetition is so important. Once you become incapacitated, you cannot create or modify these documents. So it will require two doctors to deem you incapacitated in that situation. I will say that if you're in a coma or something like that, then obviously doctors are going to deem you incapacitated at that time. But there could be other situations where you're not as drastically, incapacitated as being in a coma, and you're sort of like on the brink a little bit. And now that people can't visit you in the hospital, and the team of people in the medical community aren't seeing you, I can't emphasize enough that you want to update these documents and make them immediately effective, so people on the phone can call and check on you and know how you're doing, and talk to your team to make decisions for you.
Right, and I want to emphasize that. You want, some people will come to us and say, well, I don't really want someone to be able to immediately make decisions for me. For me, then it's a question of who you appoint, not whether the document is effective upon your incapacity. So when you create a document that's triggered immediately, it doesn't take away your right or your ability. It doesn't do that. What it does, it removes legal barriers to having multiple independent physicians declare you to be competent for these documents to be effective. And so I would say that any document, like a canned document that you buy, will be silent as to when the document is effective. And the default rule is if it's silent, then it's two independent doctors. And that's kind of where we really, really push for people just to make it effective immediately. If you have a problem with your agent, do not choose that agent. And if there's been a change of your relationship, that's why you have to keep these documents updated, because the problem is not when the document is effective, it's who you choose as agent. Okay. So
and think about if it's an elderly person, we have a lot of clients who are elderly, obviously, and they're at home right now. And so something is going wrong and you feel like you need to make decisions and start helping them. It could be the advance directive, but it could be the power of attorney. You can't get them to go see the doctor right now to have two different doctors deem them incapacitated. So in order for this person, your family or friends or whoever you trust to make decisions, they have to be immediately effective. So yeah, Din and I are both very passionate about this part.
Okay, so I'm moving on because I'm getting more questions. Okay. Next is, this is also related to an advance directive. If you have an advance directive and do not want to be intubated, how is that decision being communicated to medical staff if it is not explicitly detailed in the advance directive?
So, I have more questions to figure out exactly what that means, so I'm going to do my best. Obviously, if you're older and you have a pulse, you might have selected the level of care that you want in the pulse. If you're younger and you don't want to be intubated, and this is like specific right now to a COVID-19 situation with potentially needing a ventilator, then you have to update that in your advance directive. Your agent has the authority to make decisions for you, and they use their best judgment, obviously, given the circumstances and what they think your wishes are. But the biggest gift that you can give them is a very, very detailed advance directive, because they are standing in your shoes in critical times, and the only way you're going to be certain they're going to honor your wishes is if they're laid out. And so most advanced, or I would say every advance directive that we see that's coming in from another attorney, or the CMA form or whatever, even Kaiser, whatever it is, does not have a lot of detail on your definitions of quality of life.
I would say that most of the documents have a box that you check that says do not prolong life. And so that's going to be on the CMA, that's on Kaiser, that's on 5 Wishes is pretty good, because it's not really set up as a legal document. But I would say that, the difficulty for us as estate planning attorneys in we can't capture all the situations in which the advance directive would be used. And so what you have to do is trust the judgment of the people that you appoint. They have to know, this can't be a surprise to them. You have to talk to them. You have to have discussions about what you want. And your wishes will change over time based on your own physical being, based on you taking care of a loved family member, based on you having an experience of someone who's had a situation. Then you're just like, oh my God, I need to create one or update it. So let me get on to the next question. Oh, but sorry, just so we can't capture every situation. So the way we do it is just based on your quality of life, and assuming you're going to have conversations, your agent will have conversations with doctors. And so, you cannot trust that any advance directive will have, if this happens, then do this. So that just has to be communicated by your agent based on what they know of you and your wishes. Okay. So the next question is, what happens to your debt when you pass away? That's a really good question. And that's actually something I was dealing with today. So let me take a stab at it.
You can.
So it depends. And that's a very lawyerly response. But really it depends, because it depends on how much debt you have. It depends on whether there's a probate. And it depends on how much assets you have.
And what your debt is.
Right, and what your debt is, whether it's a secured debt or whether it's a non-secured debt. And a secured debt, an example of that is anything that's tied to the home. There's collateral that you've signed, right? So your mortgage is a secured debt because it's tied to your home. If you fail to pay, you get foreclosed on. That's a secured debt. Versus a credit card is not a secured debt. And so what often happens is, like, if you have a Chase credit card, Chase will call and they'll call and they'll call and they'll call. If there's a probate that's open, they will file a creditor's claim. And so creditors have 1 year after your death to file a claim against the estate. If you already filed for a probate, then they will file the creditor's claim in the probate. If a probate hasn't been filed and the debt is large enough, then the creditor has the right to open their own probate. And it is just so weird talking. I have two computers right now, and I'm answering these questions, and I'm just talking to the computer, knowing that you guys are out there. Okay, so the next question I have is, can my sibling who has autism create his own power of attorney?
So it depends on his mental capacity. If you think a physician or a psychiatrist or psychologist would say that he has capacity, then yes, he can create his own documents. If the answer to that is no, then obviously if he's over 18, then there would have to be a conservatorship. There are different levels of capacity for different documents. So the advance directive and power of attorney are the highest level of capacity. Then a will is significantly lower than that, I would say, and a trust is potentially somewhere in between. We did learn a few years ago with an elderly client situation where the caregiver married him, and the daughter was outraged, as you can imagine. They had a silent wedding, so like the court records were sealed as far as that goes. Right. And so the capacity to marry is the lowest, where you just have to say one time, yes, I want to get married. And then divorce is a little bit higher, because throughout the divorce proceeding, you have to say, I maintain that you want to get a divorce. So the different levels of capacity address what type of document or what the action is that you're taking.
Mm-hmm. And the capacity refers to mental capacity as determined by a doctor.
Yeah.
So next is, what are the costs associated with creating a trust?
Less than a probate. How about that? It's hard to say, because we have to know exactly what your situation is. So We create our flat fees based on how much work we're going to be doing. And so you can have, you know, a $2 million estate and have 5 small properties in terms of value, and your estate plan is going to be a lot more than someone who has $10 million or $15 million and they just have 1 house. So it really ranges. There are, you know, there's online ways of creating it very cheap. We don't recommend those unless you have, you know, no kids or maybe 1 kid, but the details aren't going to be very great in those. And, you know, those could be, I don't know, $1,000 or something like that. There are these legal service kinds of clinics or businesses that, like We the People or things like that. We have not seen any good results from packages like that. If we had more time, I'd share a story of when I called one of them and what he said. My jaw was like literally on the desk. I could not believe what he was telling people.
Right. And the hotel lobby estate plans for $7.95. You know, you see ads in the newspaper.
You sort of get what you pay for, unfortunately. And
Exactly.
and our malpractice insurance in terms of all types of lawyers is the highest, because you don't learn that the estate planner screwed up for 30 years from now, right? When you need to use it. So whereas in personal injury, you know, within a year or 2 when your case is over. So so we're sort of in the mid-range of that in terms of prices. I think our quality is really great, I will say. But it depends on what it is. So I would say, you know, there are places, law firms out there that might charge $3,500, $4,500. We start at $6,000 for a couple. But we're not tacking on all these things along the way. So a lot of these places will say, well, here's what it is. And then as you get into it, I've heard stories where they're, you know, tacking on, well, it's extra for this and this and this. Whatever the fee is that we give people up front is sort of what it is. Right. And then there's super high-end big firms. They charge a lot more for the documents.
So I would say, you know, it's, if you go to an attorney, if usually someone who's doing this not as many years probably will start at about 3,000, 4,000, and then it goes up from there. So, but that you're looking at committing, you know, $4,000, $5,000, $6,000.
But then think about this probate, right? So you're like, okay, so let's just say I'm at $5,000 to make the math easy. What is that compared to those crazy probate fees?
Right.
So
right. It is worth the investment. Okay. Next is, what documents and info should I prepare or bring to streamline the estate planning process?
So I can really only talk about our process, and every lawyer does it differently, but we send out a getting started email that is very user-friendly. We do a lot of hand-holding. So basically, there's a 2-page questionnaire that you could spend 5 minutes filling out. There's an assets sheet in Excel that we want to know your assets so that we can be sure the funding gets done at the end of the process. And then there's a 3-page workbook that we have each client send us in advance, and we will talk through all of those issues in great detail. Our first meetings are between 2 and 3 hours. Right now we're doing everything via Zoom, but I look forward to being able to sit with people in person and give big hugs at the end. So once we're done with that, people have their homework, and then when we get that back, we can start drafting. Our final meetings for signing are being done outside, so we can still notarize. They're really fast meetings, and then thereafter people will talk with Din to talk about the funding and the details of transferring assets into the trust. So that's kind of our process. But in terms of the beginning part, it's just working through our workbook, and then we'll need deeds for real estate.
I think that any attorney who does this, and this is actually one thing that I really want to emphasize, is you want to go to someone who practices estate planning. You don't want to go to someone who advertises that they do 4 or 5 different things. This is an incredibly difficult area of law, and it covers a lot of different areas. So I actually have to, we have to actually be really good at 5 different areas of law to practice estate planning. And so if you should not, I mean, please, please, please do not find someone who is a criminal attorney who will do your bankruptcy, who will also, do your divorce and then do your estate plan. I would never, ever, ever practice in a different area. I wouldn't do criminal. I wouldn't do, family. Even though I used to run the self-help center in Compton and I did family, I would not do it. I would just send my clients who need help with family matters to a family law attorney. These are very different areas of practice. I see that we have my friend Tuan, he's an attendee, and he is a bankruptcy attorney and practices solely, and he teaches bankruptcy as well. So, I would go to him for bankruptcy questions.
And think of it like in the medical community, if you have a heart problem, you're not going to your general GP, you're going to your cardiologist, right? And you have a brain tumor, you're going to your neurologist and not like the person you see for your GI issues. So we are just as specialized as you all are in the medical community. And there are many, many, many lawyers out there. If you look at their website, the first thing I would go to is what are their practice areas? And if you see anything except estate planning, we do elder law because that's the end of estate planning, right? But if you see 5 or 6 areas of law, like run for the hills.
Well, they might, but just make sure that this is not a big firm because they might have different departments. But if they're like a
True.
small practice and they have, but what I wanted to answer to that question is that every attorney will help you and tell you exactly what they need. So you can do planning, you can have conversations with your spouse, you can, figure out what your assets are, but a good attorney will guide you to get through the process. Okay. So I'd like to get to the next question. It's elder. I have elderly parents. They have a trust, and they have a house. And would it be wise to sell their house or transfer it to their trust? They plan to sell the house and move into our house.
So you're saying whether it should be in the trust or out of the trust when they sell it?
I think so. I think that's the question.
So it doesn't matter. We always recommend that you transfer the title of your house to your trust so that if something happens, you avoid probate. But if they are in the midst of wanting to sell it, they're going to sell it as themselves or they're going to sell it as the trustees of their trust, and that part won't matter. Remember, they will have to deal with capital gains. So maybe a second part to that question for other people might be, should my parents just pass the house to me now, give the house to me now while they're alive versus leave it in the trust? And we always recommend, assuming they bought it a long time ago, to put it in the trust and pass it at their death. So you get the step up in basis of the fair market value as of the date of death. So when you go to sell it, there aren't huge capital gains compared to inheriting their basis if they gift it to you during life. And then, maybe they paid $40,000 for it and now it's worth $800,000 and there's a huge capital gains in there.
You can also sell it upon the death of the first spouse, first parent. You get the step-up basis then as well. And what that just refers to is the lowering of capital gains taxes when you sell the house. So it might be a good idea to keep the house in trust just to lower your capital gains if the difference of the price that you sell versus the difference of price that you buy is great. So, that is definitely something that you want to consider, but it doesn't matter whether you sell it outside of the trust or inside of the trust. Think of the trust as being your legal avatar, okay? For the IRS, it does not matter if you have a trust. They look through the construct of the trust, and you so really, in trust or not, it's just being in trust protects you from probate. Okay. So the next question is, what is better, a revocable trust or irrevocable trust?
So it depends on each person's situation, but 95% of the trusts that we create are revocable. Revocable means that you can change it at a later time. Irrevocable means that technically you cannot change it at a later time. So for younger people who are creating these estate plans, they want to be able to modify this and change it later. They don't want it to be sort of stuck in time in that way. So irrevocable trusts, at least in our practice, are done for tax planning purposes. The estate tax is so high, it's over 23 million right now federally, and we don't have an estate tax in California. So if you have less than 23 million, you don't need to worry about estate taxes. So the irrevocable trusts that come to us that might need some attention are usually created a while ago when the estate tax was lower. And so we tend to recommend revocable trusts so that people can update them.
And a lot of times people create an irrevocable trust because they think there's a reason to. And I think that there are strategies that you can use in revocable trust planning that usually satisfy the goal, the need. And so what I often find is when I get to the why, I can come up with better solutions for them. So
they give more flexibility.
Exactly. Yeah. So over, I would say 9.5 out of 10 times people come to us wanting an irrevocable trust. Once we talk to them, discuss the pros and cons, we're moving to a revocable trust structure. Okay, the documents Rebecca mentioned, are they for people to do now if you can't create a full estate plan?
Yes, so I know we only have 2 minutes left, but if you go to that tiny URL at the bottom of the screen in red, you can download the documents that we talked about, just the advanced directive power of attorney and the will, and then the samples that Din created for you. You can print all of those out and fill them in and sign/notarize them accordingly. And then when you're ready to do your trust, or you're ready to beef up those documents and have a lot more specificity and customization, then you can do the full estate plan. So this is meant for you all to like handle it immediately and sort of triage the situation and get these documents done, but it is not meant for a long-term estate plan.
Okay, there are 3 more questions. I'd like to get through them so that we might go a little bit longer, but I just want to make sure that we cover all 3 questions. Okay, what do you look for in a person to deem them a good agent? That's a good question.
So for the Advanced Healthcare Directive, this is what I share with people. First and foremost, it has to be somebody who's going to put their wishes aside to honor yours. And this may sound straightforward and easy, but we've all heard stories of situations where maybe somebody is religious or not religious if you are, and so their end of life protocol is very different and values are very different than yours. It might be a spouse who's unable to let you go, or children who are unable to. It's a really important decision and conversation to have to make sure that if your wishes are different than what you think your agent would want, that they're able to put their wishes aside to honor yours. Secondly, I always tell people, it should be someone who's local or who's willing to come here and get things set up for you. And then, there are people to hire to help if there's the finances available to do that. And third, I say it's somebody who has to really advocate for you. They need to get second opinions and they need to ask lots of questions and understand about trial studies and different things. And then last, but certainly not least, it should be someone who is a good communicator and mediator within your family, with the teams of people at the hospitals, so that your person, whoever it is going to get the best care possible.
Right.
On the financial side, it should be somebody who's really good with paperwork. It's not somebody who doesn't open their mail for 2 years, and who's on top of the technology to streamline that process to pay bills, who can deal with all of the bureaucracies that the power of attorney needs to deal with. So I think those are the, and it doesn't matter to me if they're nearby or not, because technology allows us to sort of be anywhere for that.
Can I add one also?
Yeah, what's yours?
For financial, is that they have to be in an okay financial situation.
Oh, absolutely.
They cannot, you know, you can have friends who, or family members who are wonderful people, but, and not but then, well, but, you might have them taking over your finances. And if they're in financial troubles, you know, it's just, you're just putting this like apple, you know, this delicious apple in front of a hungry person. And so
the temptation is too great.
It's just too great.
And it's not fair. And we've seen those situations where clients kind of haven't had a choice as to who they name. And those people have taken advantage of it, and really enforceability is going to court. And if there isn't money or the inclination to do that, it becomes very difficult. And if that person has already lost capacity and the durable power of attorney is the one who's committing the elder abuse, let's say, then the logistics and procedural part of getting to court is extraordinarily difficult.
Right.
So it's really important.
Mm-hmm. They have to be trustworthy and just financially sound, you know, and just, okay. So next is, can the documents be e-signed? This is a great question.
So unfortunately, well, as of like a few days ago when I last checked, California did not allow these e-signing notaries. And so some of the documents need to be notarized. And so the advance directive can be witnessed for sure. The one that, you know, we're providing to you can be. A holographic will can certainly, you know, it's just your signature. And so those are fine. But in terms of our full estate plans that we're doing, we want to make sure financial institutions will honor this. And so we really need to notarize certain documents. So that's why we're signing them outside. These are like 10 or 15-minute meetings. You know, bring your own pen. You've given your driver's license information in advance, so we're not sharing and touching things. And then we know for sure that these documents will work.
Of the 3 documents on our website and Rebecca referenced, the power of attorney, the statutory power of attorney, has to be notarized. Okay.
Without exception.
Notarized. The statutory will has to be witnessed. A holographic will has to be, it does not have to be witnessed, but it has to be in your own handwriting. And the advance directive does not need, you do need witnesses. You need 2 witnesses.
Doesn't need to be notarized.
Notarized. Okay.
Yeah.
And then finally, this might be a specific question for us, but let's just make it general. Do attorneys accept payment plans, financing?
So I kind of think that a lot of attorneys will be doing that now with everything that's going on, to be as accommodating as possible. We have always had payment plans for people. So most people pay everything up front, but certainly when people need payment plans, we work that out.
So those are all the questions. Thank you.
So I just want to say thank you all so much. I know that this is a scary time for you, and I know that talking about these issues is not at the top of one's list of comfort, but it is so important. So thank you all so much.
Absolutely. Thank you. And please let us know if we could be of service. Take care, everyone.
Take care. Be
Bye-bye
safe.
now. Be safe. Bye.
Bye.